Senator Surovell, you want to present your bill?
Happy to, Mr. Chairman. Though I hope we can spend more time on it than we did on undue influence. But, Mr. Chairman, first thing I want to do is just walk everybody through what the bill text does so everybody understands what we're voting on. So there's no substitute to the bill. If you pull up the version that's drafted, it is pretty straightforward, but there's some nuance to it so we're clear. The first section of the bill gets rid of some, it makes clear a FOIA reference. The next piece, the few pages, have to do with habeas corpus and deleting habeas provisions. Lines 371 through 381 is really sort of the meat of the bill, and that basically eliminates the provision of the death penalty, and it changes the term capital murder to aggravated murder throughout the code, so that basically everything that was formerly capital murder in the code will be aggravated murder going forward. It also makes it clear that the maximum penalty is life in prison with no parole, and the person in prison cannot benefit from any earned sentence credits. If you want to know what qualifies for capital murder, that's on lines 463 through 506. Then the rest of the bill sort of eliminates references to the Capital Defender Service, to death sentences, lethal injection authority, and if you're curious also about there's a bunch of repeals at the very end in the enactment clause that has to do with the commutation.
Senate Bill 1165. Senator Surovell, you want to present your
championship in football, right? But we're not taking wagers on that. But seriously, we have the death penalty issue. Senator Surovell, 1165. He can speak, and then we're going to have the public. I think a number of people would like to speak. We'll give, without objection, 10 minutes to each side. That's 20 minutes entirely, 10 minutes each side. And I'm going to turn it over temporarily to Senator Deeds.
Senate Bill 1165. Senator Surovell, you want to present your bill?
Happy to, Mr. Chairman. Though I hope we can spend more time on it than we did on undue influence. But, Mr. Chairman, first thing I want to do is just walk everybody through what the bill text does so everybody understands what we're voting on. So there's no substitute to the bill. If you pull up the version that's drafted, it is pretty straightforward, but there's some nuance to it so we're clear. The first section of the bill gets rid of some, it makes clear a FOIA reference. The next piece, the few pages, have to do with habeas corpus and deleting habeas provisions. Lines 371 through 381 is really sort of the meat of the bill, and that basically eliminates the provision of the death penalty, and it changes the term capital murder to aggravated murder throughout the code, so that basically everything that was formerly capital murder in the code will be aggravated murder going forward. It also makes it clear that the maximum penalty is life in prison with no parole, and the person in prison cannot benefit from any earned sentence credits. If you want to know what qualifies for capital murder, that's on lines 463 through 506. Then the rest of the bill sort of eliminates references to the Capital Defender Service, to death sentences, lethal injection authority, and if you're curious also about there's a bunch of repeals at the very end in the enactment clause that has to do with the commutation. It repeals provisions about the commutation of sentences, limits on habeas corpus, the jury trial process, claims of intellectual disability, the Supreme Court review, and the right to counsel. Because all those become no longer necessary if we adopt this. And then line 1754 basically commutes the sentence of two people who are currently in jail for capital murder, in prison for capital murder, to a life sentence in prison. So that's basically sort of how the mechanics of the actual legislation works. But getting to the actual bill itself, Mr. Chairman, what I would say is, first of all, you know, Our state began its journey towards capital punishment, at least under the English experience, in 1608 at Jamestown. Captain George Kendall was the first person executed in the United States under European rule by a guy for treason. Since then, we've had hundreds and hundreds of people executed, 113 in Virginia since Furman v. Georgia in 1976. We're second only to Texas. There are 6 problems, I believe, with the death penalty as it's currently administered. First of all, the biggest problem is that we often have executed the innocent in this country. Today, we've had 143 people who've been on death row who've been exonerated, people who were sentenced to death who turned out were actually innocent, mainly because of DNA evidence, but a few others, I believe, for other reasons. But executing the innocent is probably the absolute worst thing that our government could ever do. And it's one of the big problems of this. You can't take it back. Earl Washington is the Virginian who is most famous for this, and I think everybody's familiar with his situation, but he came within, I think, 2 weeks of being put to death before we realized that we were making a horrible mistake, and he's now free. Second thing is this bill, or the second problem with the death penalty is that I think it's impossible to get a fair trial today. Last year, Gallup updated, they do a poll every year about the death penalty. 43%, I will come and bring you a copy, Senator Norman, but 43% of Americans today are morally opposed to the death penalty. 43% of Americans say they don't want to see it applied to anybody. 60%, when polled, say they think a life sentence is a better remedy for murder, a better punishment than murder. And I don't know how anybody is supposed to get a fair trial when 43% of the public is excluded from their jury because they think there's an immoral punishment involved. And if you're entitled to a constitutional trial jury of your peers, and 43% of your peers, at least nationally, are excluded from the jury, probably higher than that in Virginia, can't even sit on the jury, I don't know how you're supposed to get a fair jury under our Constitution. That's the second problem. Third problem, I think if you look who we stand with internationally, it's become embarrassing. China executes the most people of anybody in the world. Next is Iran, Saudi Arabia, Iraq, Egypt, and we stand right between Egypt and Pakistan, Somalia right after that. And there's not a single Western industrialized country that still engages in this practice. America stands alone on this. And in fact, we were passed for a couple of years by ISIS. But, fortunately, they don't exist anymore. ISIS was leading the world for a while. But, these are the kinds of people who we stand with as we continue to engage in this practice. The fourth problem I would identify is equity. There was a good op-ed in the Virginian Pilot, I believe 2 days ago, by 4 black ministers from around the state who talked about the death penalty's long connection with racial oppression and how it became popular at a certain point in time. I would also point out that you're much more likely, all kinds of evidence points, you're much more likely to get the death sentence in this country if you're poor, if you're not white, especially if you killed somebody who is white, if you have diminished intelligence, if you have brain injury, or you're mentally ill. Our system has never properly accounted for those types of problems. The fifth thing I would say is that administering this punishment is insanely expensive. Virginia right now spends $3.9 million on our Capital Defender Service every year, and that does not include the costs we spend on expert witnesses, which are paid outside of that budget. It also does not monetize the amount of time that's spent by prosecutors, attorneys general, judges, clerks, police officers, and jurors administering these types of sentences. This is an extraordinarily expensive way to invest our public resources that could be better spent in other ways that would deter and prevent less crime and less people getting harmed. And the last point I would make, Mr. Chairman, is that I believe that the way this system is being administered today, with a lethal injection cocktail, which is largely secret, I don't think really fully appreciate how it works. To me, is kind of abhorrent. I know we made a little bit of progress restoring some transparency to the lethal injection cocktail last session, but our system has put itself into pretzels trying to figure out a way to continue to do this in accordance with our existing principles of transparency, due process, and what Americans expect, and it's becoming increasingly impossible to do it. So, Mr. President, I would hope that we today could stand with 60% of Americans who don't think this is a worthwhile punishment to use anymore, and we could repeal this from our code. I'm happy to take any questions, but I know there's a lot of people who want to testify.
Okay. Yeah, all right. Now we have the substitute in front of us. Who would like to go first? Who supports the bill? Again, starting now, 10 minutes on each side.
Mr. Chair, I know the Governor's Counsel, Rita Davis, is on the line.
Okay, Rita Davis, the Governor's Counsel. Rita, welcome.
Good morning. Thank you, Mr. Chair. Thank you, members of the committee. Good morning. I'm Rita Davis, counsel to the governor, and I'm here to express the administration's strong support for this bill. As the governor stated, our criminal justice system must operate fairly and punish people equitably. Historically, the use of capital punishment has been inequitable. Similarly, historical evidence reveals that the death penalty cannot be imposed or has been imposed against the innocent and those deprived of due process. The Death Penalty Information Center documents that across the country, there are several instances of defendants sentenced to death, executed, and posthumously pardoned. But even if we look at Virginia, as Senator Surovell noted, since 1973, Virginia has executed more than 1,300 people. 9 days before Virginia was to execute Mr. Washington, DNA evidence proved his innocence. How many brothers, sisters, fathers, mothers were in that 1,300 who were Earl Washingtons, who were punished and executed not because they were guilty, but because they didn't have access to the evidence that could prove that they were innocent, or their trials were not viewed through the lens of equity to ensure fairness. It is because of the inequitable use of capital punishment and society's inability to ensure its impartial and unbiased application that it can no longer be countenanced as a criminal penalty. Indeed, the likelihood that such punishment has been applied unfairly, inequitably, and unjustly in one instance eradicates any justification for its application in any instance. For those reasons, Mr. Chair, the administration strongly supports this bill. Thank you for the opportunity to speak to it.
Okay, thank you. Any questions? Thank you, Rita. All right, next from the public, who would like to go next?
Judge, Chairman, this is Doug Ramsey with the Virginia Association of Criminal Defense Lawyers.
Okay.
Good morning. I'm here on behalf of the Virginia Association of Criminal Defense Lawyers, and I'm an adjunct professor of law at the University of Richmond, where I teach a course on capital murder litigation. And I was the capital defender for Central and Southeastern Virginia for 10 years. Over my 25-year legal career, I've served as lead counsel for more than 30 people charged with capital murder. And for 25 years, I've been walking into courtrooms and purporting to have dignified discussions about whether or not we should make one of the other people in the room stop breathing. And Virginia has been doing this for over 400 years. I've represented Black men, white men, Hispanic men, and one woman. I've defended people with mental illness and people who are innocent. As recently as September of 2020, I defended an innocent man at his trial for capital murder who had been held for 4.5 years until a judge hearing the evidence at trial dismissed all his charges. But I have never once represented a rich person. There may have been a time in our history when execution was necessary to prevent and protect our society, in the days when jails struggled to contain outlaws. But there's one thing I know America is really good at, it is incarcerating people. And people serving life in prison at some of the lowest rates of violence in prison. There are plenty of moral reasons to abolish the death penalty. There's no denying that it's racist and values white lives over Black ones. It has the potential to execute innocent people, and it's just plain unnecessary. But after 400 years, we also have to recognize that it is just bad policy. Virginia is spending millions of dollars for a punishment that does not work. It does not decrease crime and is not likely to result in an execution. Of the 30 people that I've represented, not one of them has been executed. There are 2 people remaining on death row from Norfolk, whose Commonwealth attorney supports abolishing the death penalty. I'm here asking you to put me out of business. You have the opportunity to demonstrate that Virginia is a more humane state and a more just state, and send a powerful message to the other states that continue to execute people. The Virginia Association of Criminal Defense Lawyers asked you to pass this bill. Thank you, and I'll take any questions that you have.
Okay, thank you very much. Any questions? Okay, next, who else from the public?
My name is Emmanuel Harris. A statement has already been made. I'm the president of the Baptist Ministers Conference of Richmond and vicinity. We've already made a statement in support of the bill, as well as with the Black Coalition to Change. This is a justice issue. The data shows that this is used primarily on African Americans, particularly poor ones. The data shows that if you're a Black person killing a white person, you are 3 times more likely to get the death penalty. The data shows in Virginia that overwhelmingly that Blacks, even since 1982, have been 46% of the people executed, whereas we only account for 19-20% of the population. The data shows that African Americans have a different justice system in America. This is just another example of a system. And let me say from personal experience, I've had cousins, very close friends murdered, and the victim, the offender never got the death penalty in those cases where it was black on black. We often say that 90% of crime is black on black and 80% of crime is white on white, which is true. But the death penalty is really used when it's black on white crime. It wasn't until 1997 that a white person was actually sentenced to death for killing a black person. So this is a justice issue, and I want to speak in support of this bill.
Okay, thank you. Any questions? All right, the next person, I'm not sure who.
Mr. Chair, this is Jennifer Givens from the Innocence Project at UVA Law School. And I just wanted to add a few statistics to the discussion. The most recent research suggests that there is at least an error rate of 4.1% in capital cases. That means that 1 in 22 people sentenced to death are innocent. It also means that approximately 100 of the roughly 2,500 inmates currently sitting on the row are innocent. And since 1973, there have actually been 174 death row exonerations, including just 6 last year. For every 9 people executed in this country, 1 person on death row has been exonerated. If we want to eliminate the risk of executing innocent people, the only way to do it is to pass this bill, which we support. Thank you.
Okay, yeah, Jennifer Givens, thank you very much. The next person.
This is Jim Hensley. I'm the Albemarle County prosecutor. Before I became prosecutor in Albemarle County, I was a criminal defense lawyer, public defender for 44 years. In that time, I represented 4 individuals charged with capital murder as lead counsel. All 4 of those were African Americans. I echo the comments previously made that the administration of the death penalty is racist. But what I really want to talk about is the cases that could have been charged as capital murder that I saw in my career as a criminal defense lawyer and public defender that were not charged as capital murder. I had at least a dozen, if not more, of those cases. They met all the requirements for a capital murder charge, but they were not charged capitally. And so oftentimes we hear in the debate that we need to keep the death penalties to separate out the worst from the worst and use the death penalty for the worst of the worst. Let me tell you, there is no way to evaluate what is the worst of the worst. That is just not a workable way of looking at the system. Those decisions are made, the pre-charge decisions, the ones that are separated out when nobody even knows about them, are made for a variety of reasons: lack of prosecutorial resources, the advocacy on behalf of the victim. Sometimes there's not much advocacy, so the case doesn't go forward as capital. Sometimes conversely, there's a high-profile victim who advocates for a capital murder prosecution. The decision-making process is entirely arbitrary in terms of separating out the cases that are deserving, in some people's view, not mine, but deserving in some people's view of a death sentence, and those are not. So that's another reason that this committee should support this bill.
Okay.
And
right.
the arbitrariness.
Yeah, thank you. Any questions? Okay, the next person, I can't really tell.
Good morning, Mr. Chairman, and members of the committee. I am Reverend Lakisha Cook, here on behalf of Virginia Interfaith Center, which represents over 20,000 people of faith across the Commonwealth. On the day that we pause to celebrate our justice warrior, Dr. Martin Luther King Jr., I want to share this. When Dr. King was asked about capital punishment, he responded, "I do not believe that God would approve of the death penalty for any crime, rape, and murder included. Capital punishment is against the better judgment of modern criminology, and above all, against the highest expression of love in the nature of God." We fully support abolition of the death penalty. Thank you so much for allowing me time to share.
Okay, thank you very much. Any questions? Who would be next? And I can't tell.
Good morning, Mr. Chairman and members of the Senate Judiciary Committee. My name is Eli Jones. I'm a third-year law student at the University of Virginia School of Law and a member of the State and Local Government Policy Clinic under Professor Andy Block. I'm here to testify in favor of the bill, but these views are mine and not the views of the law school or the university. But if the Commonwealth were to abolish the death penalty this year, we wouldn't be alone. Virginia's consideration of abolition follows a trend of other states across the country, showing that we see this practice as outdated more and more. In the past 20 years, 7 states have abolished the death penalty via legislation, and 3 more states have actually found the death penalty unconstitutional in their state Supreme Courts. In addition to that, the governors of Oregon, Pennsylvania, and California all have imposed moratoria on the practice of capital punishment, which additionally sort of shows that we're more and more viewing this nationally as an outdated practice. Even in Virginia, the practice of sentencing defendants to death has faded away. The last time someone was sentenced to death was 10 years ago. And as of today, there are only 2 people on our death row. So the death penalty has been shown as something that Virginia can clearly live without, and for the reasons that all the other speakers before me, and I'm sure some after me, are going to give, should live without. So Virginia now has the opportunity to leave this outdated practice behind and join the national trend away from this outdated practice.
Okay.
So I hope that the committee will support this bill.
Okay,
And
thank you. Any questions? Who would be next? Almost 10 minutes has gone by. Anybody else that wants to speak against the death penalty and for the bill?
Yes, this is Dominique Martin, policy research analyst, New Virginia Majority. I would echo the sentiments presented earlier by other speakers and just put particular attention on Virginia's particularly racially discriminatory usage of the death penalty, and also just realize that the prospect of potentially executing an innocent person is probably the biggest affront to justice that we could possibly face, and therefore on those grounds we should support the abolition of death penalty. Thank you.
Okay, does anybody insist on speaking?
I would like to say something briefly.
Go ahead. Go ahead.
Can you hear me?
Go ahead.
Okay, my name is Ms. Love, and I'm here on behalf of the Black Coalition of Change. I just wanted to say that throughout history of this country, Black people have been punished by longer, harsher sentences and put to death at higher rates than any other people. The death penalty is a part of our systemic racism in this country, and it's time to end it. We are in the year 2021, and we are still using barbaric practices, and that is why I support this bill.
Okay, thank you. Is anybody else?
Yes, I would like
Who's
to.
in favor of the bill?
I would like to say
Very
something.
quickly. Okay, go ahead.
My name is Jabril Hassan, and I'm also a representative of the Black Coalition of Change to speak in support of Senate Bill 1165. As a disclaimer, though my organization is not an explicitly spiritual group, I do speak as a spiritual person and also a lifelong citizen of the Commonwealth of Virginia. I come with the basic understanding taught by the Judeo-Christian tradition, to which so many in the Commonwealth subscribe, that there is nothing and no one beyond the power of redemption. From a basic humanist perspective, capital punishment is premeditated murder. You have heard the observation, we kill people who kill people because killing people is wrong. Accordingly, the state should not have the right to execute its citizens. Rather, we are to find it in our hearts to do the work of restoring the whole person. And I know that you all are doing a lot of head work today, but what does your heart say? Furthermore, you all are aware of the death penalty's racist history in the Commonwealth and its disproportionate use against Black citizenry. Note especially that a Black defendant is 3 times more likely to be sentenced to death if the victim is white rather than Black. Let it be known that those who uphold this policy are accountable, not only for their general response to the bill, knowing the history, but also for the deaths of every person executed under the death penalty. Thank you.
There are 3 other people. Brave, give it 30 seconds each. We've gone over. Go ahead.
I'd like to add in favor. I'm one of the 43% of Americans Senator Surovell described who are morally opposed to the death penalty for anyone, no matter the crime or act. And I say this as a woman, as a mother of 2 children. I've seen people who have been victims of violence in my community, in my inner circle of friends and family. And regardless, as a committed believer in nonviolence and care for our communities and community healing, which includes accountability, the death penalty goes well past any justifiable consequences. This is state-sanctioned murder, and we remove any chance for restitution or correction of mistakes, which people have demonstrated how many have been killed and then found to be innocent. Even 1 is way too many. It's also established as a legacy, another legacy of white supremacy and deathly oppression enacted against our Black communities in Virginia. And as a white community member, I'm asking you to change our course and support this bill.
Okay, thank you. Rachel Sutphen, whose father was murdered by Morva, she would like to speak.
Yes, thank you, Mr. Chairman. As the chairman stated, my father was killed in 2006 by William Morva. He was the last man executed by Virginia in 2017. I speak in support of this bill because I believe the death penalty is an ineffective and outdated measure that brings no solace to family members. The state would better spend their time and their money providing resources for my family versus killing another person. Thank you for your time.
Yeah, thank you very much. Is there anybody else that would still like? All right, go ahead, Lisa Gershik, is that right? Go ahead, speak. You have 30 seconds. Go ahead. Lisa?
Yes, Mr. Chairman and members of the committee, my name is Lisa Gerchik. I speak on behalf of the League of Women Voters of Virginia in support of SB 1165. Capital punishment violates the ban on cruel and unusual punishment in the 8th Amendment to the United States Constitution, as well as the equal protection and due process clauses of the 14th Amendment. Imposition of a death sentence depends to a significant extent upon the effectiveness of counsel, the race of the victim, and the circumstances of the defendant. As a result, some guilty parties are condemned to death while others receive a lesser sentence. What is worse, innocent people have been convicted and executed. From a purely economic standpoint, capital punishment costs the taxpayers. Keeping an inmate on death row costs tens, if not hundreds of thousands of dollars more each year than maintaining that person in a supermax prison. Mandatory appeals to the highest court in the state cost at least $70,000, and appeals to federal courts can cost an additional $275,000 or more. Drawn-out legal proceedings waste the time and energy of the courts. A lack of closure exhausts and inflicts pain on the families of the victims. As studies show, the death penalty is not an effective deterrent to crime. The death penalty is immoral. A just society should not use death as a punishment.
Okay, Senator Surovell, you want to wrap it up?
Sure, happy to, Mr. Chairman. Thank you, and I appreciate the conversation we've had. I think it's been very enlightening and helpful. First of all, I want to address some of the things that I heard in the testimony opposing the bill. I think I heard somebody advocate that we ought to have the death penalty available for children or for at least young adults, which to me left me scratching my head. I think it's important to remember where the Supreme Court of the United States has taken us on this over the last 3 decades. In 1987, the United States Supreme Court in Schumann held that the death penalty cannot be a mandatory punishment. It can only be administered with the consent of a jury. In 2002, the Atkins case, the U.S. Supreme Court, which is a conservative court, all these rest of these cases were all a conservative court, found that we're not, or held that it's unconstitutional, violates the 8th Amendment to give the death penalty to somebody who was intellectually disabled. At the time, they used the term mentally retarded. In 2000 and in the Thompson case, which I think was in the early 2000s, the U.S. Supreme Court said we cannot execute anybody who committed a crime before the age of 15. Then in 2005, in the Roper case, they held we cannot execute somebody under the age of 18. In 2008, Kennedy versus Louisiana, the Supreme Court had said it was a violation of the 8th Amendment to give somebody the death sentence for a non-homicidal offense, things like rape or I don't know what else it used to apply to in 2008. And then in 2019, just 2 years ago, the U.S. Supreme Court held that we cannot execute anybody who has suffering from dementia, that violates cruel and unusual punishment. I want to make clear that no one who supports this bill is anti-law enforcement or wants to do anything to put our law enforcement officers any further at risk. From my perspective, anybody who's dumb enough to take a shot at a law enforcement officer is probably asking to be killed. I mean, you're going up against somebody who's armed, and the idea that having a death penalty on the books is going to deter somebody who's that stupid or reckless or craven, I think, doesn't hold water with me. I don't think it deters people in those situations. And I also just want to make clear, lines 1754 to 58 of the bill specifically state that anybody who's currently on death row, the 2 people that are there today, will get life in prison, not eligible for parole, not eligible for in-sentence credits, and not eligible for geriatric parole. They are in jail forever. The cases that were cited earlier were people who were decided under our old system, our pre-parole system. They're not people who are in jail. They've been sentenced since 1995. And the last thing I would just say, Mr. Chairman, is, again, I didn't hear anybody in testifying in opposition really address this. But just remember who we stand with. I mean, the American justice system, Virginia's justice system, I don't think we aspire to stand with countries like Egypt or Pakistan or Saudi Arabia or ISIS. I think we aspire to lead the world in having a fair and humane justice system. And this piece, I think, is an important part that we need to move on from and join the rest of the world, at least the rest of the industrialized world, in not administering this punishment. I'd hope we support the bill.
Mr. Chair.
Is there a motion to report the
Second.
substitute and re-refer to finance?
Move to report and re-refer to finance.
Mr. Chair.
Moved and seconded that we report and re-refer to finance. Will the clerk call the roll? Vote aye if you support the bill, vote no if you don't.
Ayes 10, nays 4.